Hi everyone, welcome to the latest roundtable in our compliance series. We'll be asking an SEC staff member your burning questions on the private fund exam process, which I can tell you have only become more sophisticated and targeted as the years go on. I'm Navatar's Nicholas Donato, and I'm going to be your moderator today. Very shortly, I will introduce you to April Evans and Maryellen Maurer. But first, some housekeeping. Throughout today's conversation, I encourage you to submit any questions using that GoToWebinar widget on your screen there. We have given ourselves about an hour of time, and I'm going to do my best to reserve about the last 15 minutes for an audience Q&A. Secondly, let me say that recording of the webinar will be emailed to all attendees after the event, so look for that in your inboxes. And allow me to tell you what led to today's conversation. In May, an important speech was delivered for those of us who track compliance in this industry religiously. The SEC's Director of Enforcement delivered a speech, or actually I'm going to call it a warning, to private equity firms that more enforcement cases were on their way, that the Commission was still seeing problem areas during their on-site visits. And then the SEC delivered on that promise. Last month, WL Ross settled charges it wasn't doing a good job of disclosing how it charged investors certain fees. Soon after that, Apollo, another big-name firm, paid its own fine for accelerated monitoring fees. And then just this month, First Reserve settled charges that it wasn't sharing discounts. It was negotiating with its lawyers with fund investors. And this is important stuff. GPs have been taking a hard top-down look at their fee disclosures, their expense allocations, other areas flagged by examiners as problem areas. And now this has all been going on for a few years, and fund lawyers will tell you that huge improvements have been made since 2012 when Dodd-Frank pushed most of the industry under the SEC's brighter spotlight here. But clearly gaps remain. So we want to talk about those gaps here today. Let's talk about the recent enforcement cases. What can firms do to avoid facing their own charges? What does it mean to create a culture of compliance? That's a phrase that we hear often. How should GPs be thinking about cybersecurity, valuation, fee practices? And what should we anticipate next? The SEC just recently floated new rules on business continuity planning that may be a future focus area during exams. Now, to help me talk about these issues intelligently, I recruited the help of April Evans, who I've known for some years now as a former industry reporter. April is the first name that I thought of when Navatar started organizing this roundtable in partnership with ACG, and I want her to take the lead here in directing some of the questioning. She is the CFO and CCO of Monster Clipper Partners, a middle market firm. More importantly, for our purposes here, she is co-chair of ACG's Private Equity Regulatory Task Force, or PERT, which is a task force comprised of industry professionals that has been speaking with regulators like the SEC about new rulemaking. April will provide you the details on PERT in just a bit. We also have with us Maryellen Maurer. She had rejoined the staff of the SEC's Office of Compliance, Inspections, and Examinations in December of 2014, where she focuses on private funds. More recently, though, she served as Deputy Chief Compliance Officer with TPG, a firm I'm sure that we all recognize. Maryellen, in fact, I'm going to kick things over to you real quick to give us a disclaimer.
Thank you, Nick. And if you put up the disclaimer. There you go. The Securities and Exchange Commission, I have to read this, sorry guys. The Securities and Exchange Commission, as a matter of policy, disclaims responsibility for any publication or statement by any of its employees. The views expressed herein are those of the author and do not necessarily reflect the views of the Commission or of the author's colleagues upon the staff of the Commission. So in short, these are my opinions and not necessarily those of my colleagues or the Commission. Thanks, Nick.
Thanks, Maryellen. Now, how does Navatar fit into the picture? Well, we are a cloud services provider for the financial services industry, and one of our aims is to ensure that clients bring a disciplined approach to their deal origination, to their fundraising, to their relationship management workflows. Basically, what we do is we offer GPs more structure and formalized processes that not only make the shop more lean and efficient, which is pretty important at a time when regulators and investors alike are taking a pretty critical eye to firms' operational risk management, but it just brings that overall discipline to your approach. April, can you provide us some background on what PERT is doing?
Happy to, Nick. Absolutely. PERT is the Private Equity Regulatory Task Force. was formed 2 years ago, just about exactly, to advocate and interface with federal regulators and policymakers on behalf of middle market private equity. What we do is we're creating a network of peers to develop and share best practices. We educate PE professionals on regulatory issues that have a direct impact on us and our funds. We're now 50 members strong. We're close to issuing best practices on 5 areas of SEC focus for private equity RIAs. We've begun addressing best practices for a 6th, and we've held 2 fly-ins and dozens of meetings with both members of Congress and the SEC on private equity within this regulatory framework in which we live. We've done a lot of good work, but there is clearly more work to be done. There are about 500 attendees on today's webinar, which is quite impressive. I encourage those of you in PE firms to reach out to PERT to become a part of the dialogue in our efforts, and those of you who are service providers in the PE industry to identify ways, such as Navatar is doing, to work with us. Feel free to reach out to Amber Landis. You can see her info at the bottom of the screen, alandis@acg.org, with any questions you might have at all about PERT. It is doing some really good work with the SEC and with Congress these days.
Thanks, April. And PERT is recruiting from people across the country. Is that right? People can join in from conference lines. They don't need to be physically there in person for every meeting. Is that right?
Correct. So we hold, for example, quarterly conference calls where we are discussing issues, updating everyone on the call about latest developments, and then strategizing next steps as well. And those are held on a quarterly basis.
Cool. Thanks, April. So let's get started. So what are we doing here today? As I alluded to earlier, we want to talk about the exam process. More broadly, we want to talk about how the SEC approaches its supervision of the private funds industry. We want to talk about what it means to create that culture of compliance, and then we can drill down into a few specific areas like fees, cybersecurity, and valuation. And then we want to analyze a few recent important enforcement cases, as well as some rule proposals that are in the works. So Maryellen, I know that you prepared some thoughts for us on ways that the exam process has evolved since much of the industry was forced to register 4 years ago. Can you take us through those thoughts?
Sure. And so on the next slide, so we thought it might be helpful to first quickly step back to discuss how the SEC oversees private equity from an organizational standpoint. So these 2 slides are basically a bit of an outline. So you'll see on the first slide in front of you 3 groups within the SEC that are responsible for the day-to-day oversight. So those include the Division of Investment Management, so that's primarily the rulemaking body. So when you think about what goes into the Form PF, the ADV questions that are being asked with regard to private equity funds, advisors, and funds, those are the folks. They also cover no action letters if you want some kind of relief or exemptive relief. For example, a political contribution issue, you may submit that to IM. We call them IM. The next one is Division of Enforcement, and they become involved when there's a potential issue with the firm. So the administrative proceedings that you're seeing in the press, they're the ones that handle that. And then there is the Office of Compliance Inspections and Examinations, which I'm a part of. And the short name for that is OC. And that's where all the examiners that will show up in your office sit. So they are the boots on the ground. And then on the next slide, you will see that in each of those divisions, or OC, there are individuals who work on issues specific to private funds, including private equity funds. So I want to go through each of those. So within the division of, the larger division of enforcement, there is what's called the Asset Management Unit, or AMU. And the individuals in enforcement who work on investigating potential issues with private equity firms are located there. So these folks have industry experts that assist in their cases. So those people sharpen document requests, testimony, devise any kind of investigation thesis, build analytics around the thesis. And they include their attorneys, but they include a former portfolio manager that was with an alternative investment firm as well. And that unit was created in 2010. And so it's been around for almost 6 years, and they work very closely with OC. And then within the Division of Investment Management, there's another team of lawyers who make up what's called the Private Funds Branch, and they've absolutely developed expertise in the private equity area. And a person whose name you might hear of a lot is Alpa Patel, who heads that up, and she gets out to the industry a lot. And then finally within OC sits the Private Funds Unit, and that's probably the unit you're most familiar with. And this was a unit that was started in 2014. And why was it formed? It was formed because the National Exam Program Management, which is OC is a part of, recognized that the private fund space generally is complicated and diverse, and therefore needed some specialized expertise that was widely distributed around regions with the highest concentration of private funds. And they felt that would benefit the industry and the commission. So almost 2 years in, and that team is growing to 25 permanent members. And those members don't necessarily come to the unit with expertise in the space, but rather grow to that by conducting focused exams where they develop pattern recognition of issues. And the PFU folks, however, still do include people from the industry, including myself, and others that have come from private equity or in the accounting area, operations, legal, and portfolio management. And that group is supplemented by a larger group, which is called the Private Fund Specialized Working Group. And there are over 120 members in that group, and they are dispersed all throughout the divisions and offices. They're basically people that are interested in the private fund space and private equity and develop expertise. And one thing that I wanted to note is the PFU will not necessarily be the only ones going out on private equity exams. So anyone in any of the regions who's an examiner could be on a private equity exam, so not just the PFU. When you think about 25 people, they're not going to get it to all of the private equity shops. And then also, we wanted to note within OC, there are two groups that provide assistance in identifying issues, and one is the Office of Risk Analysis and Surveillance, and they are the ones that will go through the filings and look for any kind of keywords or inconsistencies in your filings, so an ADV or Form PF. And then the Office of Chief Counsel as well, and they are the ones that will look at any particular issues that are coming up from a legal standpoint on exams and try to write analyses to help the examiners when they go out in exams to ask the right questions. For example, when with Blackstreet issues that have come up, so that's something where the Office of Chief Counsel will assist the examiners on asking the right questions. Or is a co-investment vehicle an actual client? That's something that will be analyzed from a legal standpoint.
Thank you. I'm sorry, did I interrupt you, Maryellen?
No, I just want to make a couple more points. I know this one is a lot, but it's important. So the PFU, as far as getting more sophisticated, one of the things it has done is actually meet with LP groups like members of ILPA and other state pension plans to understand their concerns and get feedback. And it also helps with some initiatives that we develop. So for example, Igor Rosenblatt, a week or so ago, he flew out to a state to meet with 30 people across a state's 9 pension plans to go over those kinds of issues, and it was a great dialogue. And then it's helped us to better understand the GP and LP relationship and what we should be asking for.
Thank you, Maryellen. That's a really helpful layout for those of us in middle market firms to understand how the SEC is approaching the overall responsibility of reviewing and examining our firms. As the SEC conducts an exam, how do you all think about the relative size and resources one firm has available compared to those of another firm in the context of a compliance program, cybersecurity controls, etc.? Is there a one-size-fits-all philosophy to addressing compliance matters from your perspective?
Okay, so having worked at a very large PE shop myself, when I conduct exams over the past now almost 2 years, not quite 2 years, I'll often, if I'm examining a small to mid-sized PE shop, I'll often hear, you won't understand that my firm is not the size of so-and-so, we are a small shop, we all know each other and have worked together a very long time, and people here have to wear multiple hats. And I won't understand that. So what I say to that is there is a natural scaling to the regulations and enforcement of those regulations. For example, if you don't have a certain amount of assets, you make certain filings less frequently, or with regard to Form PF, you don't necessarily need to fill out the whole Form PF. Also, you might not be dealing with the same issues that you see in the cases in the press, such as operating partners, senior advisors, accelerated monitoring fees, or with regard to cybersecurity, you may have fewer systems that you're working with or outside people who would be accessing your information. And so you may need fewer policies and procedures because you don't engage in these certain activities. So all of that is natural scaling. I do want to say that we see nothing inherently bad about having multiple hats if you can handle all of them. We do pay attention to whether or not you can actually handle all of them. And oftentimes, an outcome of our exam is your firm decides on its own to add more compliance resources or to shift some of your compliance hats over to somebody else. So in short, there's going to naturally be the need for fewer, less complicated resources with regard to compliance. The rules say that you have to have a program that's, quote, right-sized for your business. So we are not looking for something that's outsized. We don't expect there to be a one-size-fits-all. There's obviously always a nevertheless, and the nevertheless is the rules are the rules, and they apply to everyone. So, for example, your governing docs have disclosures that are funded, that go over what a fund expenses are and management expenses, and those need to be followed regardless of your size. So your fund's assets are your fund's assets, and anytime the management company seeks to take some of that, no matter what size you are, you want to be sure that you've disclosed that fully. And you might not have, because we definitely see in mid-sized shops, people have senior advisors, operating partners. You might not have 50 of those. You might have 2, 3, but the same issues occur with regard to shifting of expenses to the funds from the management company, and you can't ignore that. And then if you have any kind of material conflicts between the fund and the management company or the GP, you want to address those. And there are certain things that go before the advisory board, or if you call it the advisory committee. And actually, sometimes we see more of that in the middle market shops as firms are trying to grow. There's more potential conflicts of interest. And then with regard to private securities, because it doesn't matter if you have private securities, if you're a large firm or a small firm, you need to value those at fair value, and there's a process around that. So finally, there are many obligations and requirements as a registered IA, which we call investment advisor, from a compliance standpoint. So whether expertise is internal, external, or a combination thereof, we don't care. We just want to make sure that you're addressing your issues and are knowledgeable about your business.
Thank you. Thank you. That's helpful and comforting, frankly, to hear as that the smaller firms have that you do understand a natural scaling to the ways in which we are approaching our compliance programs, building them out and then managing them. It's very helpful.
Okay.
What are some best practices managers can follow to ensure that the exam process goes as smoothly as possible? So we get the best practices thing in terms of building out programs, but then the exam process.
Yep. The first piece of advice I would give is be prepared before we arrive. And I think most importantly, and you'll see that in all of these cases, these sort of keywords, conflicts of interest. So know all of your conflicts of interest, how you handle them, how you work to mitigate them, and how you actually disclose them. You can lay those out for yourself in a document, spreadsheet, database, whatever works for you so that you're filling any gaps. So when we come in, you don't necessarily have to hand it to us, but you're able to talk to us about it. That's going to go a long way. Also, there's plenty of sample request lists that you can find out there from whether you use consultants or attorneys. Go through those and test your production time. You'll often find, and I certainly do this myself all the time, find things take a lot longer to produce than you think, and it's a lot more difficult to produce certain things than you think. And then almost equally as important as the conflicts of interest issue is To be prepared, you need to read SEC speeches and cases. So members throughout the SEC, and we'll tap ourselves on the back on this, I think we're very good about getting the word out there and what we care about, and this won't necessarily be done by wrapping up a report and sending out a risk alert like we did on business continuity that we published, but rather it's done through speeches or articles where we're interviewed, things like this. And to date, most of those have come through the two co-heads of the private funds unit, so Igor Rosenblit, who's been around for a while, and Jen Duggins, who joined the SEC last year from the industry. But as the private funds unit more solidifies, that will come from other people. And you'll also hear, obviously, from Andrew Koresny in enforcement, who I know you guys know about. So that's before the exam. During the exam, I would say first, the CCO, no matter how many hats he or she wears, needs to know the business and have a knowledge of the responsibilities with respect to compliance. So that's even though we hear oftentimes that we always ask the question, what percentage of your time do you spend on compliance? And typically it is definitely below 50%. What we want to be sure is during an exam, you don't leave us with the impression that compliance is an afterthought. Or alternatively, which we do find people will say, we think it's really important, and then we ask you what you actually do, and you can't really point to much with any kind of specificity with regard to compliance. You may go over personal trading, and you know the other side, which is oftentimes the CFO's business quite a bit, but it's compliance that we're there to talk about. And that will give us really leave us with an impression and decide what we need to do there. So I'm just going to leave that point. But then on responsiveness, that's another key point. From the moment we start the exam, it's really important to be responsive to us. We're not in that often after you've registered. You don't know when you're going to see us, and then say you've been examined. The next time you be examined, it could be many years later. So it really should be all hands on deck, and that's not just the compliance piece of that. We've seen things be unsuccessful if it's left solely to compliance and we don't get the responsiveness. Next, I would proactively communicate with us. So don't let us be the ones following up with you to ask if you're, when you're going to be producing something. If it's going beyond a deadline maybe, or beyond, say, the 24 to 48 hours since we asked them, just give us an update. That said, what we don't want to happen is for you to produce inaccurate information because you're rushed. So if there is a need to slow it down for you to produce the information, that is as important as giving us accurate information, and timely information is important. Two last things I would say is, which we do run into, so if you are using consultants or outside counsel to review the documents before producing them to us and then stamping them, for example, which we do see in mid-sized shops, all different shops, you need to bake that into your production time. So we don't give you extra time to do that. It's your prerogative to do it, but understand that the deadlines are there, and however you want to manage those deadlines, just manage them. And then lastly, because I've been on the receiving end of many exams throughout my career, I personally always tell firms before I leave the firm that once we are off site, we may contact you right away and ask you more questions and interviews, and maybe a few weeks before we do that. And the exam may go on for a while. So it really is not going to be helpful to yourselves to try to gauge if your LPs, for example, are asking when the exam is going to end, how has it been going. It really isn't going to be helpful for you to answer that because you're not going to have a gauge. Something could be going on for a long time, really unrelated to the exam. People are tied up with other things. It may mean something negative where we're pursuing something with your firm, but it may simply be, again, administrative issues. So it's really not helpful to gauge it.
And Maryellen, this is Nick jumping in. Real quick question, because this is really important for the mid-market level where you have few senior decision makers. During that on-site portion of the exam process, what would it mean to you if somebody was on vacation, or if they're traveling, or they're working in a different country and they can't be there on site, and not just for the CCO, but say the senior managing director, is there leeway in trying to reschedule an exam? Is the expectation that somebody comes back on site to answer your questions face to face? Any insights to share on that?
Sure. As far as the leeway on the start date of the exam, there's not a lot, frankly. The reason for that, in part, too, is before we even do this contacting to you, there's been multiple, lots of hours spent on coordination. Who's going to be involved? When is it going to happen? Where do you sit in the risk reward scale for us? So there's a lot of work that goes into it before we examine you. So moving the date is difficult. As far as being on site, we don't care if somebody in that role is going to be on site. We have calls all the time with people. I just was on an exam. Somebody was in Singapore, somebody was in Taiwan. We have the phone calls, and the people on the other end make themselves available, whether it's at 11 at night or 5 in the morning. It's to your best interest to keep the exam going, but there will be flexibility around that. If somebody's on vacation, we don't require them to come back. Recently, somebody was in, I want to say Maine, and I was in Connecticut. We're not going to require them to come back. If they can get on the phone, great, but we try to keep the exam moving. So there's some flexibility, but typically not on the start time.
Thank you. Thank you for that. And I took a little bit of comfort in your statement that sometimes slow, you're not getting back to us to wrap things up, has not a thing to do with what's going on within our firm. It has to do with your other administrative responsibilities.
Yes.
So getting worried doesn't get us further down the road. Let's, if I can, shift us to some specific categories of SEC interest and focus over the last few years. Largely, private equity firms have improved our disclosure of fees and expenses, but we're still hearing from SEC officials that we as an industry have more work to do. Can you give us some details about what that means?
Sure. The short answer is there's still an opportunity for advisors to improve documents. And those are governing documents and DDQs. It is something for advisors to think about and to take action on rather than waiting for us to arrive and tell you what to do. And unfortunately, that is still a scenario that we are often in. And we understand that the governing docs have been produced a long time before we arrive, and it may not be practical to have them changed as we've come out and said these speeches about what we're concerned about. However, before you allow the advisor or the GP to collect some form of compensation or share in compensation that takes away an asset that could go to the LPs, you need to be sure that your documents or disclosures were in place before someone committed the capital. That's certainly something you're seeing lately in the cases. Before somebody is actually committing capital, they need to clearly understand where those expenses are going. So that may actually involve you using your LPAC or advisory board more often to get approval for some compensation, and then notifying LPs that you're taking the action, and then take the action, so not taking it before. So next, the advice I would give to middle market shops based upon what we are seeing is to try to rethink, so go back through it, whether or not you are actually engaging in any activities that you see us talking about in the papers or speeches or in enforcement cases. So oftentimes, and part of it, we hear an immediate, no, I don't engage in that activity that you guys just talked about. But then when they think about it more and we ask more questions, they come back with, oh, we probably do something that's similar to that in this particular category. So think about that before we arrive. And then next, on expense shifting, we unfortunately is still seeing plenty of evidence of expense shifting. So the best thing a firm I'd recommend doing is to sit there, take apart the schedule of fund expenses, and be sure all of them are properly disclosed to the LPs prior to the commitment. So that's an action that you can take. Some expense shifting without proper disclosure that we still continue to see That includes use of related party service providers, which appear to be full members of a manager's team, so operating partners, senior advisors, some captive consulting firms, and again, doesn't matter what size you are because we are seeing this in the smaller shops. And advisors who look and appear like they're employees of access, and you don't have controls around them, so they do have access, and their expenses we know are not offset. They don't offset management fees per the documents, but they look like employees to us. Next, software costs. Think about, is that software cost that you're implementing to actually make the business better, is that really a management expense, or is it a fund expense? Is it somehow benefiting the fund? Outsourcing traditional back office functions to related parties around accounting, legal, and risk. Regulatory filings is certainly something we are seeing. People are hiring firms to use help with Form PF, Form ADV, the 13 filings, those kinds of things. Just think about, is it a fund filing and it comes under your fund obligation, or is it coming under your advisor obligation, which means a management company expense? Insurance, which is something you see in first reserve. So are those payments really covering the funds, or is there a piece that's covering the management company? So I was on an exam where there was insurance that was covering cybersecurity, great, covering cybersecurity. A portion of that, once we started asking the questions, it turns out that a portion of it was information that could be stolen from employees, so not related to the funds, was being protected, and the funds were covering those expenses. It wasn't something that the firm was trying to do intentionally and trying to have the funds pay for it. Simply, they didn't ask the questions enough. And then falsely informing investors that the advisor is charging, quote, below market rates. So this is where investors agree to expenses being recovered to the funds by claiming investors are saving money by not using third parties. But the management company actually isn't fully providing the services that you would see at a third party, and there's no documentation of any efforts to support the statement that the services are actually below market rates. That's an area that definitely firms need to work on. And then with regard to fees, rather than going into detail, the Fenway Partners enforcement case action that was in November of last year, if people reread that, that's an area that obviously the cases are fact specific, but that topics in that case are something that we are definitely seeing still on the fee side.
Thank you. That's quite a list. I guess we do have, we feel like we've made a huge amount of progress, and a lot of what you've described doesn't apply to all firms, but we should focus on those things that do resonate for our particular firms, and make sure that we have understood it properly, calculated it properly, and can explain it when you come to visit properly. Let me shift gears to valuations for a moment. It's certainly valuations also continue to be a focus for the Commission. From your vantage point, where have valuation practices gone in the past 4 years? And in what areas does the industry still require improvement? And allow me to pile on, if I may, one more question in that category. Given the fact that fund audits spend a great deal of time on valuations, why does the SEC still believe it's an important area of focus for the SEC, given the attention that all of our PCAOB compliant audit firms are, the attention they're paying?
Sure. So valuation practices definitely have become better in terms of increasing the consistency of documentation around the processes, being able to produce for us the backup of how values were arrived at, ensuring that the committee is looking at the same underlying materials every time, and also some checks and balances. So that is improved. So some areas that still need improvement is we still find that everyone is not actually being fully transparent to the LPs about their practices, so how to go about doing valuation. There's a summary document. It's good, but when you get into the details, it is best to be more transparent to LPs. So the best thing a private equity firm can do to ward off any kind of accusations is absolutely to be transparent on how they derive valuations. So the LP should be able to review the methodologies used by portfolio companies and clearly understand it in detail. So for example, if there is a valuation summary page that you give to the LPs, they should be able to understand everything that's on that summary page, and you should be able to explain that to them. In terms of the act of approving valuations, the reason why there's still some improvement to be had there is we see two ends of the spectrum sometimes, and that's where there's somebody in the valuation process that very much it's very much ruled by a strong person. Or on the other end of that, you have a committee that really is relying on the underlying team, and it's not asking too many questions, being a bit too trusting, and then not looking at the inputs. So they're relying on junior people for inputs and not asking them questions about, is this really the right control premium? Is this really the right trading multiple? Who are you using as our peers? We're seeing summary information going to the people that are actually approving. I know we're running tight on time, so if I think about the staff, why does the staff think that this is an important area of focus? Firms are still obviously still out there raising money at any time. So inflated values in valuations can be deemed misleading to investors with respect to performance, particularly at fundraising times, and these are often at times even when it hasn't been audited. So right, it's interim valuations that are going on, and we see interim valuations as important as LPs base whether or not they're going to invest in the next fund based upon what that last fund did. And also there are times when I know it's not that frequent people transfer in and out. There's secondaries that are occurring, so that's all the reasons why we think it's important. As far as the auditors, we do put some reliance on the auditor's role and get some comfort from that, but we're still asking auditors questions, and the auditors will tell you that. We ask them about their how they look at reasonableness of methodologies. We look at what testing that they're actually doing. We'll look at their work papers. We'll go on site and look at their work papers. We also then compare that to what the GP is telling us when they do their own reviews and how they're working with the auditors. The auditors sometimes find all of the issues and sometimes they don't. So we can't give 100% reliance on what the auditors are doing. We basically have to look at valuations as if the auditors sometimes aren't there. And I would say we do have a senior specialized examiner that focuses on valuation that works very closely with the private funds unit.
Thank you. I think it's probably helpful that there are increasing numbers of folks from industry who are in valuations illiquid, and so they are very difficult to value to begin with. So that's got to be a helpful thing to have folks within the SEC understanding how those illiquid valuations have worked historically in industry. Let me shift gears to cybersecurity, if I may. It's a relatively new area of focus for the SEC. Although most PE firms have been addressing our own IT security matters all along. And of course, one of the challenges with cybersecurity, we've all known this all along, is that we never know if we've done enough. You can never be 100% secure, and safeguards can always be improved. Can you provide some insight on what the SEC expects of middle market firms in this category? Again, going back to that earlier question of differing amounts of resources available to those of us in middle market firms compared to the titans in the industry.
Mm-hmm. Okay. Well, cybersecurity has been, it continues to be, definitely, as you said, it's an area of focus for OC. And while the federal securities laws do not specifically address a firm's requirement for cybersecurity preparedness, just know that there are rules and regulations tangentially that address the firm's responsibility in the area. So these regulations, Regulation SP, Identity Theft Rule, regulations involving safeguarding of books and records, which you hear about a lot, and then the compliance rule, that's a specific rule for investment advisors. So in 2014, the staff conducted reviews of 105 firms, and 49 of those are investment advisors, all different sizes, including middle market firms. And observations from those reviews are in a risk alert that was published on February 3rd of 2015. And just go to the SEC website. It's a good summary of the sweep and the results. And then phase 2 of our cyber review was announced and outlined in a risk alert that was issued in September of last year. That's called the Cybersecurity Phase 2 Initiative, a good document for you to look at. So similar to the 2014 exams, the results of the 2016 exams have been shared with the SEC to help inform the Commission and the staff on industry practices, but we don't know yet whether or not we will make the results public. And as part of that initiative, there are about 50 different firms across the U.S. that were examined. So what we expect to see is basically that you can readily answer questions about what your vulnerabilities are and what you're going to do to address it. And we absolutely understand that there is only so much that can be done, but you have to decide yourselves where that spot is. We can't tell you that or opine on it.
Maryellen,
yep.
Nick jumping back in here now very quickly too. One of the things that I've seen since joining with Navatar is this big debate in the industry too about whether or not the firm should migrate its data to the cloud. I've heard from some CFOs that they like seeing the data systems on site. I've heard from others saying, no, it's more secure to have it in the cloud. You don't have to worry about business disruption as much. The software is more advanced. Does the SEC take a view on that within the overall context of cybersecurity?
So the short answer, just like what I just said before about us opining, the SEC does not opine on whether or not you can use the cloud. We don't say there's anything wrong with your using the cloud. But what we do say is you should establish a set of standards for protecting client information. And we want to see what your standards are that you're using and be sure that they are protected. So there are tools out there that can be helpful for you. There's something that's called the Federal Financial Institution Examination Council, and they have a document that, by the way, the SEC isn't a member of that council, but if you go to their website, they have some tools on there that are helpful to identify the risks and determine your cybersecurity preparedness, including related to the cloud. So they give you some ideas on what cloud service providers should be providing to you, what questions you should be asking. So these are things that we will ask about. So what are you looking at in your agreements? An example is using Dropbox. We went on one exam and the firm was using Dropbox, but they were using the one that anybody can use and sign up for, and there aren't necessarily controls around that, and the service provider can access the information versus the other Dropbox service, which is the corporate service where there are controls around that. And so that is important. And also, one thing, just a side note, is if there's any kind of password protection going on, that you need to be sure when using the cloud that if we come in and ask for documents, if your service provider cannot go in and reset those, reset the passwords for you, that you have a way to do that. So in short, we are not saying that you can or cannot use the cloud. We ask you about controls around it.
Thank you. Thank you. Let me shift to one more recent thing, if I may, and that is that in June, the Commission proposed a new rule that would require registered advisors to adopt and implement written business continuity and transition plans. How is this any different from the compliance program rule, which already requires us to have these policies in place? Are we missing something here when we scratch our heads and say, but that's already a rule and we're already doing it?
In the wake of Hurricane Sandy, so OC reviewed business continuity plans, and that was approximately 40 advisors that in impacted areas to see basically what the issues were, and they detailed that again in a risk alert. And then the National Exam Program, which is again part of OC, that's published a compliance alert after Hurricane Katrina, and those can be found on the SEC website. And as you said, this past June, there's this new rule that's been proposed. and that's to require investment advisors to adopt and implement a written plan addressing how to provide continuous advisor services and protect client assets and information in the event of a business disruption. So the one thing to note is the proposed rule is more prescriptive, what I guess I would call more prescriptive than the part of the current compliance program rule that relates to business continuity plan. In the compliance program rule, it's not specifically mentioning business continuity in the rule. It's discussed in the adopting release, and the adopting release provides examples of what areas we expect to be covered, and it talks about business continuity generally. So that's more principles-based. So the actual proposed rule requires the advisor to have a plan based upon the particular risks of the advisor's operations, and more specifically to include policies and procedures addressing specific components. So it's specific. So maintenance of systems and protection of data, prearranged alternative physical locations, communications plans, review of third-party service providers, and then a transition plan in the event the advisor is winding down or is unable to continue providing advisor services. So there are a lot more elements to this rule, and it goes into with fair specificity about what is needed versus the current compliance program rule, which talks about it more generally. So it's the Commission's belief that basically proposing this rule will assist advisors in preserving the continuity of the services in the event of a business disruption. So that's something that's temporary or permanent. So there are a broad array of things, so national disasters, cyber attacks, technology failures, key people leaving, which wasn't necessarily discussed previously, and then similar events. If that's helpful.
Thank you. Thank you. So it's more of a the June is more of a specific roadmap, if you will. Sounds like
exactly.
Thank you.
Good point.
Thank you. Thank you. Nick, I know that you're the one who's receiving questions from folks, so let me turn it to you because we had wanted to cover several enforcement cases as well as you had Q&A, and so let me turn it to you in the interest of managing our time effectively here.
Yeah, let's breeze through some audience questions. I want to make sure that we get some interaction here. And then if we still have time by the end of the hour, it would be important to hit some of these enforcement cases. So Maryellen, just your quick thoughts, a few questions. How much advance notice does the SEC typically give before they come on site for an exam?
Sure, and it does vary. I can say if you, the private funds unit gives a longer leeway if you're subject to one of their exams, and that's typically can run up to 6 weeks in advance. If you examined otherwise, it typically is in the 2-week time frame. If it is a shorter time frame, again, do not presume it means something that somebody is called an enforcement issue on you. It could mean that, but I would say the 2 weeks is fairly normal unless you're being examined by the private funds unit, which is a longer leeway.
I see. We have another question coming in. This is someone asking, what if the CCO, and I'm guessing that this would be a CCO that wears multiple hats, so doubling up as a CFO, delegates a lot of the compliance work to someone junior, so that they're only doing maybe 20% of their time on compliance and the rest of the day on other stuff. Would the SEC see that as a potential issue?
The short answer to that is no. As long as everything is being covered, we understand that people have other responsibilities, and we would hope where the CCO is spending their time is on identifying the risks of the firm, doing that risk assessment. The junior person can do the testing, the junior person can do the training, but the CCO is really the face of the compliance program. So we definitely see that it can be split between the CCO and more junior people, because frankly, a lot of the compliance work is very detailed and sometimes administrative things that need to be done. So we understand that, but please think about the CCO has to be involved in knowing the risks of the firm and making sure that you're addressing that. That can't be delegated to the junior person.
We have a question related to the valuations portion of the roundtable. Someone wants to know, would the SEC have a preference or see one way it's better than the other to have an LP committee look over the valuations and oversee the process, or they prefer having that be more in-house, led by the CFO. Any thoughts on that?
We don't have a preference. We are seeing as valuation becomes more of an issue that firms are bringing in outside entities, and that could be the LP that are part of the, obviously they're invested in the funds. So there isn't a preference between the two. We're seeing mixtures, and it can be done either way. I do want to say on valuation, because it's something I forgot to mention earlier now that somebody's bringing up this question. We are seeing compliance people being a little too hands-off for what we are expecting. So the compliance should know not just the process, oftentimes they're part of the committee, but to be able to do the testing around, okay, you haven't changed the transaction multiple or trading multiples in this, 6 quarters, and now you're suddenly changing it. You're suddenly introducing a firm that you didn't introduce before. They need to know about why that's happening and whether or not it's appropriate. So we know that, so going back to your question, LPs have experience, we understand, and then internally this experience. So good with you there.
Another question coming in that appears simple on the face of it, but may actually be difficult to answer. What is the best source for compliance training? Have you gotten that question from CCOs? Is there any resources that you generally point towards?
Yeah, so we don't say anything as far as just because we can't endorse any kind of vendors or anything like that. I would say to start with the SEC speeches in this topical area. So the SEC speeches that are sitting on the website. In addition to that, honestly, if you can sign up for lots of law firms, we can't tell you who, but there are lots of law firms that are fairly specialized in this area, and they will send out newsletters and alerts when things come out. That's an excellent source of training. They summarize things for you, and then you can read all the detail. But I would heavily emphasize the speeches and the articles that the SEC is actually talking about. And then lastly, obviously, using a consultant, which I know it can be expensive for small to mid-sized shops, but having somebody come in to give you some information initially, and then maybe being part of the alerts is a way to get information that's helpful for people that are seeing things across the U.S.
Another question, if you have an organization that has multiple teams, units, and only one of those is a private equity unit, would an exam ever just focus on that one unit, or would it always be part of the organization as a whole?
So without knowing more detail about the question, so if I'm going to have to phrase the question, so if the whole entity is a registered investment advisor and there is one unit that within that is private equity, yes, we could just focus on that one unit and not look at the other piece of the firm. We may look at it from the outset of understanding the business and how that business flows through in any interactions with the other, I want to say units or divisions within the larger organization. Because as you see in cases where you're looking for conflicts of interest, so that conflicts of interest between management company and funds, but also potential conflicts of interest with other units, or flowing of information between units. So say you have a hedge fund unit, and say you have a private equity unit or an asset management unit that's not even private. We could just still focus on the private equity division, but understanding how you interact with the others.
One final question, and then I want to kick it back over to April to talk about some recent enforcement cases in our last 5 or so minutes here. It's on cybersecurity. Any thoughts, opinions on if a firm's able to produce a data map? So I'm guessing this is some way to trace how all the data is moving throughout the firm.
Yep. Yep. So that is incredibly helpful for us. Not helpful when I say helpful, not helpful for us in the sense of us poking holes in what you're doing, but to seeing that you're covering the issues and that you're thinking about it. and it makes the questioning go a lot more efficiently, and it makes us understand that it may be an area that you absolutely are thinking about, and we can move on from it. So that is something I certainly worked a lot on in my other firms when I was being examined, because a lot of times it was something that naturally should have been in place but wasn't, and when you're examined, it's helpful.
Thank you, Maryellen. There are, as you know, there have been a number of cases recently that have gotten a fair amount of attention, and perhaps in the last few minutes we have available, we could focus on a couple of them. I'm thinking between Blackstreet, Apollo, and First Reserve. If we were to start with you mentioned issues with First Reserve, so maybe we don't need to focus there, but Apollo had some interesting things, an affiliated loan issue, personal expenses. Can you speak a little bit to the takeaways with respect to that particular enforcement action?
Sure. So one thing I would note too, obviously a big part of the Apollo enforcement action was related to accelerated monitoring fees, which was also the issue in Blackstone from 2014. And I do know that a lot of middle market firms don't necessarily have to deal with that issue, but just to quickly say on that, it's the whole issue about if someone has committed capital and is already in the fund, whatever disclosure they received, that's what they're relying on. So Apollo did a lot of disclosing about the fact that they were receiving accelerated monitoring fees and the amounts, and did what they were supposed to do there. But there were some conflicts of interest that they did not disclose in advance of people investing in the fund. And so that was that issue. So if we move on to the loan area, you're going to see in a lot of our, wherever you examine next by us, there are going to be a lot of questions on loans. So loans that are involving the funds and related parties. And we are looking for situations where there's a benefit to the advisor or GP that's not being disclosed to the LPs that potentially represents a conflict of interest, particularly where the fund is the lender. So that was the case in Apollo. And it's definitely something we're spending time on, and that we feel that the compliance professionals could do more to spend time on this issue. It's certainly ripe for problems. It's oftentimes not that straightforward. It's a little complicated. So we just ask that you look at your loan situation, because we'll certainly ask about it. And the other sort of fail at Apollo, I don't want to get into the specifics of it, but think about it thematically. Basically, you had a rogue individual, so a partner, submit expenses that weren't fund expenses, and the funds are paying for them. So thematically here, in conducting exams, we do see a little bit too much reliance on the investment professionals and not enough testing of their expenses, that what the expenses that they're submitting are appropriate. So whether or not they're inflated, and we really care about this because fund expenses are assets of the fund and therefore the LPs, and you should treat it like that. So taking away dollars and money from the funds is an issue for us. So one of the things that we see sometimes is an invoice that's being submitted. It will be on an Amex bill. It will be that's what's used, and it will be a hotel amount, and the investment advisor is not asking for the invoice and the detail behind that. Now, we know that at hotels, there's a lot more things that you can charge on your bill than just for the hotel stay. So those are things like maybe golf outings or other personal outings that are unrelated to doing due diligence on the deal. So that's something that you need to pay attention to and not just look at the high level numbers. And then also, just a recent example for me again was car rentals. If people are just getting that invoice and not looking at the dates of the car being rented, and it may be a quite nice car, and that's going as a fund expense, you should know that that expense is related to a deal a particular deal or sourcing a deal, and it was during a particular time, not say 2 weeks before, and oh, this was generally in the area that I was, and I'm going to put it through as a fund expense. So that's an area that, again, we think there could be some improvements.
So I think that just about does it for time here. I want to say a big thank you to Maryellen Maurer for joining us today. It's always important to hear from the SEC staff themselves about their approach to supervision and on-site visits throughout the exam process. And a big thanks to April Evans, who did a fantastic job representing the CCO community in today's roundtable. You'll see contact info for me there. Please do reach out if you ever want to team up with Navatar in doing one of these thought leadership webinars or roundtables. We're always looking for speakers to talk about industry issues. You will also see contact information there for Amber Landis, mentioned at the start of the webinar. She is always recruiting industry professionals for PERT. That's that Private Equity Regulatory Task Force that regularly meets with the SEC to talk about industry issues. On behalf of Navatar Group, I'm Nick Donato, and thanks for joining us today.